welcome. You're watching India Upfront. I'm Padmaja Joshi. It is said that 24 hours is a long time in politics, and there couldn't have been a better example than between yesterday and today. On this very show, precisely 24 hours ago, we broke the story of how Arvind Kejriwal had been granted bail by the Rouse Avenue court. It was a celebratory moment for the Aam Aadmi Party. Its leaders and supporters were out on the streets with dhols and firecrackers. They were rejoicing the bail granted to their chief. Today, 24 hours later, the Delhi High Court put an interim stay on that bail order. The dhols have fallen silent, the crackers have fizzled out. And from the judiciary to the democracy of India being hailed yesterday as an example for the world, dictatorship is back. Because what the Delhi High Court's order essentially means is that Arvind Kejriwal will remain behind bars until the final order is pronounced by the Delhi High Court, which will happen in 2 to 3 days from now. And why did this happen? Because the Enforcement Directorate immediately challenged the verdict given by the lower court. The High Court said it wants to go through the entire records before pronouncing its order and reserved its verdict for 2 to 3 days. What this means is that till the ruling is pronounced, the trial court's order will not be acted upon. It's a big boost for the Enforcement Directorate and for the Aam Aadmi Party. It is a huge setback, and they are now asking, why is Arvind Kejriwal being treated like a terrorist?
जिस बार एक बात के बारे में बार बार अरविंद केजरीवाल जी और आम आदमी पार्टी कहती है कि कोई सबूत नहीं है, सिर्फ कुछ आरोपियों को लालच देके, डरा धमका के, जेल का डर दिखा के, उनकी गवाहियों को बदलवा के अरविंद केजरीवाल को फंसाया गया है, वो बात कोर्ट में भी कही गई.
The matter is sub judice, and therefore I would not like to comment on it in detail. But I would definitely like to add that as far as the Honorable Chief Minister Shri Arvind Kejriwal ji is concerned, he's definitely lost in the court of the people's opinion. The recent Lok Sabha elections show that the Delhi has unequivocally chosen Bharatiya Janata Party across all 7 Lok Sabha seats. And if you remember, the campaign of the Honorable Chief Minister was Jail ka jawab aapki vote se. Clearly, the people of Delhi have voted in favor of the Bharatiya Janata Party, and this shows that any charade of his, the Delhi people have not fallen for it.
Now remember, the Enforcement Directorate said very clearly that voluminous evidence was completely disregarded by the lower court, and the order itself was perverse. That stand may have been validated in the High Court, but the central agency is also in the dock after observations made by the Rouse Avenue Court's now stayed order. In that order, the Rouse Avenue Court said that the ED is not acting without bias, that there was neither proper evidence against Arvind Kejriwal nor evidence of money trail or its use for the Goa elections. In response to the ED's claim that investigation is an art, the Delhi court responded by saying that any person can be kept behind bars artistically. The Aam Aadmi Party has been citing these very statements to allege persecution even now. Top party leaders say the Enforcement Directorate rushing to the High Court even before trial court's order was uploaded shows that it is acting at the BJP's behest and treating the case like one of personal vendetta, and that this is nothing more than revenge being wreaked on the one man that the BJP is scared of.
मुख्यमंत्री अरविंद केजरीवाल जी की एक लोअर कोर्ट यानी कि राउज एवेन्यू कोर्ट से जमानत मिलना मुझे लगता है ना सिर्फ दिल्ली और आम आदमी पार्टी के लिए, पूरे देश के लिए एक मील का पत्थर साबित होगी. हमारी पूरी न्याय व्यवस्था के अंदर ये फैसला एक बहुत बड़ी मिसाल बनेगा. उसका बड़ा कारण ये है कि पीएमएलए के मामलों में अक्सर ये देखा जा रहा था कि कोई भी राहत अगर किसी को मिलती है तो लोअर कोर्ट से नहीं, हाई कोर्ट से नहीं, सुप्रीम कोर्ट में जाके कोई राहत मिलती है. हालांकि और मुझे लगता है कोर्ट को साफ हो गई कि इस मामले में कोई भी सबूत केंद्र सरकार के पास नहीं है.
अभी कल ही आपके मुख्यमंत्री को बेल मिली, अभी सुबह ऑर्डर अपलोड होना था, ऑर्डर अपलोड नहीं हुआ और ईडी हाई कोर्ट पहुंच गई ऑर्डर को स्टे करवाने के लिए. इतना ये तो ऐसे हो गया as if अरविंद केजरीवाल इज द मोस्ट वांटेड टेररिस्ट ऑफ इंडिया। देश में तानाशाही इतनी हद पार कर रही है कि ईडी किसी को लिबर्टी भी नहीं देने के मुख्यमंत्री के अगेंस्ट वो स्टे के लिए चली जाती है। अभी हाईकोर्ट में फैसला आना बाकी है। आशा करते हैं कि हाईकोर्ट न्याय करेगा।
And let's take this across to the guests joining us now. Sanju Verma, national spokesperson of the BJP. Tushar Gupta, political analyst. Varun Purohit, political analyst. Ravi Srivastava and Syed Asad Abbas, also political analysts. I don't mean to make it flippant, but literally the images, Syed Asad Abbas, of the last 24 hours make it seem like seedhe oye hoye se moye moye ho gaya.
I must also tell you this, Padmaja ji, the BJP spokesperson have been doing a fantastic job as ED spokesperson. Anyway, दोनों तो एक ही बात है, की फर्क पैदा है, ओए होए या मोए मोए. Now coming straight to the point, we are absolutely aware, देश की जनता दिल वालों की तरह दिमाग वालों भी है. क्योंकि आपको बता दूं, let me just quickly read out the Rouse Avenue Court.
Hold on a second. Before you do that, hold on a second. Why are you choosing to read out the Rouse Avenue Court's order only? Why aren't you, for example, quoting what ASG has said in court? You can't choose which judgment you like. No, you are like, bhai, मैं तो Rouse Avenue Court को पढ़ूंगा. Rouse Avenue Court तो stay हो गया. That order has been stayed.
पहले सेशन कोर्ट का ही बोलने नहीं दे रहे हैं आप. दिल्ली कोर्ट तो दूर की बात है, सेशन कोर्ट का भी बोलूंगा, दिल्ली कोर्ट का भी बोलूंगा, दोनों को खुश करूंगा. Okay. So this very scenario constrains the court to draw an interference against the investigating agency that it is not acting without bias. The same enforcement directorate that without even getting a copy of the trial court order bail, they are so swift. PT Usha se bhi tez, Milkha Singh se bhi tez, they reach the Delhi High Court challenging, but over the last 2 years, they've not been able to get one single evidence against Arvind Kejriwal. No money trail against Arvind Kejriwal. Raid parade, क्या मिला? हेंगा? कुछ नहीं. संजू वर्मा जी, मैं आपको बता ही देना चाहूंगा, आप बड़ा जबरदस्त काम कर रहे हैं एनफोर्समेंट डायरेक्टरेट का स्पोक्सपर्सन बन के, आपको बधाई हो. और उसके साथ साथ आपको मैं बता दूं, the fact of the matter also, let me tell you Padmaja ji, जो ASG साहब है, राजू साहब, उनकी बहुत सारी बातें हैं जिसमें मुझे पूरा I have full faith in the ASG as well as Abhishek Manu Singhvi. I am sure the Delhi High Court after 2 to 3 days will pronounce the right verdict on the same
So
front.
If you have such great faith in the Delhi High Court, you should not be quoting from the lower court's order at all. Because as things stand right now, that order is infructuous. It has been stayed. Arvind Kejriwal has not been given bail. So literally what you have said in the last 3 minutes is infructuous.
No, did Delhi High Court say that the High Court order of the Rouse Avenue Court is null and void?
No, the Delhi High Court has stayed it, which means that they have, let's make it very simple. Essentially, what did the ASG go and say in the Delhi High Court? We have evidence. It wasn't considered in its entirety. This is a perverse order. It's a very strong word. It is a perverse order. And the High Court said, okay, let's stay this order. We will consider all the evidence that you are putting out. So essentially those findings have been struck down, sir. That is what it means. But I want to ask this to Sanju Verma. Sanju Verma, the BJP says again, and I'll come back to you, the BJP says again and again, we should trust the court. When you go to the Delhi High Court and call a lower court's order perverse, are you casting aspersions on the judge? You're almost making it seem as if the judge acted in malafide.
Padmaja, I will quote both the lower court and the Delhi High Court. I will not be selective in what I choose to quote on your show. First and foremost, yesterday, when Arvind Kejriwal's counsel, Vikram Chaudhary, he categorically told ASG Raju that Kejriwal is not directly involved in money laundering pertaining to the Delhi liquor scam. What did ASG Raju say? He told the court and he told Kejriwal's counsel, Vikram Chaudhary, you as in Kejriwal may not be directly involved in the offense, but the Aam Aadmi Party is culpable of the offense and And we all know who controls the affairs of the Aam Aadmi Party by virtue of being the convener of the Aam Aadmi Party. And hence, under section 70 of the PMLA, you are as much liable for the offence as the party that you held. These are the words of ASG Raju to Kejriwal's counsel Vikram Chaudhary. So on the floor of the lower court also, ASG Raju had said, let there be a deferral on Kejriwal's bail application for 48 hours. But Judge Bindu refused to give a deferral. And it is then that the ED and the ED's counsel, Mr. Raju, on the floor of the House said that they are going to contest this. तो यहाँ पर कुछ बैक एंड फोर्थ नहीं है. कल ही कोर्ट में एसी राजू ने क्लियरली कहा था हम इसको कॉन्टेस्ट करेंगे इन दी हायर कोर्ट, विच इज व्हाट दे डिड 24 hours hence. Point number 1. Point number 2. I have been on a zillion debates where there have been verdicts which have gone against the BJP, and I have always maintained one line. The BJP does not run the judiciary. The courts are independent. Let us not second guess and undermine our criminal jurisprudence system. And I maintain that today, but it is very important for me to read out point number 16, page number 17, के सिर्फ 3 या 4 lines to put in perspective how the order by Judge Bindu was indeed perverse, was indeed not a reasoned order and not a sound order, because these are the terms that were repeatedly used by ASG Raju while defending the ED's case. Judge Bindu has said in point number 16, admittedly the present matter is a peculiar case wherein various accused witnesses and stakeholders are involved, and neither ED nor the defense wants the order to be passed in favor of the other. However, it is not possible to go through these thousands of pages of the documents at this juncture, but this is the duty of the court to work upon the matter, whichever comes for consideration, and pass the order in accordance with the law. The key words are, she herself admits that it was not possible for her to go through thousands of pages of documents.
Okay.
यहाँ पर जब जज बिंदु खुद मान रही है, documents were not introspected upon, they were not properly dissected, they were not properly even browsed through. Do you expect the ED not to contest such a perverse order?
Okay.
The ED has done what it should have done.
So, MC Abbas, the judge says, I haven't gone through all of the documents, but I am going to pass the order. The government goes back and says, madam, we have the evidence. We want somebody else. If not you, we want the Delhi High Court to go through the evidence. Don't say this man is innocent because there is no evidence. This man, whether he's innocent or not, can only be judged after looking at evidence. You don't want to see it, MC Abbas, we will show it to the Delhi High Court. How is this dictatorship? भाई एविडेंस तो दिखाएगी ना सरकार.
Padmaja ji, I think, Sanju ji is a spokesperson. I am an analyst. You're an anchor. It's absolutely unfair, wrong, and highly condemnable if we judge the judges like Nyay Bindu. It's absolutely unfortunate that we are casting aspersions. She has all the wisdom in every manner to take her decisions.
As does the Delhi High Court.
Supreme Court.
As does the Delhi High Court. So if you are calling the Delhi High Court staying of bail as dictatorship, you are casting aspersions on the Delhi High Court.
Allow me to continue. The fact of the matter is, Sanju Verma ji said that, I will not be selective, I will quote both. Why don't you quote Sanju ji? ED spokesperson, why don't you quote? Are you acting without bias? ED, are you acting without bias, yes or no? You don't say anything on that. Rouse Avenue Court did say that ED is not acting without bias. And the final point, the fact of the matter, चलिए मान लेते हैं पूरी आम आदमी पार्टी गंदी है, गलत है, भ्रष्ट है, करप्ट मिली हुई है. But thoda evidence to दिखाइए मोहतरमा.
Interesting that you say that. Let me quote to you. You talk about evidence. Evidence तो उन्होंने voluminous documents में दिया था ना, जो किसी ने पढ़ा नहीं. And here is what the ASG, Tushar Gupta will come in on this. Here is what the ASG said in court. I will show each para of trial court's order and show how perverse it is. You can decide against me, but don't give wrong findings. The order says ED failed to give direct evidence. We have given direct evidence. Statement of Magunta Reddy is there. You can decide against me, but don't give wrong findings. We have direct evidence. Again, when Benjamin Franklin was quoted, the ASG said, this is a trial stage. At the stage of trial, this court applies. No innocent person should be punished. What is this? Is this to be considered during bail? At trial stage, you cannot talk about innocence and guilt. This is still a trial. And the third argument made in the order, sir, is that the man is holding a constitutional chair. Is holding of constitutional chair a ground of granting bail? Then any PM, CM should be granted bail in all cases. Such perverse findings. Is the government not well within its rights to at least argue that you cannot make broad sweep statements?
Good evening, Padmaja. Absolutely. The government, the agency are well within their right to call this order perverse. And because MC Abbas and a lot of Aam Aadmi Party leaders are jumping the gun and celebrating the observations of the lower court, they should perhaps direct their attention to point number 38 of the bail order, which says that the entire order cannot be treated as an opinion on the merits of the case. So all the observations made, Padmaja, and voluminous, that the agencies are biased, that there is no direct link, and a lot of other things, that the arrest is artistic or whatever that means, that is not an opinion on the merit of the case. And yet the Aam Aadmi Party leaders and their supporters are somehow claiming that the ED is biased. So yes, that the agency and the government is well within its right to argue the case in the High Court, because when the judge, and I say this with all the respect, of a lower court says that I cannot go through hundreds of pages of evidence, so I'll pass a certain order. Now that order can be of guilt, that order can be of innocence, that order can be of conviction, that order can be of bail. But it impacts the individual, it impacts the investigators. And we're just not talking about this case, Padmaja. If the agencies had not argued this case before the High Court, it would have set a very, very wrong precedent. So I'm very glad that the agencies moved quickly, they argued, and the ASG was right that if you find me wrong, might as well do not put any stay on the order. But the High Court also looked at the merits and the bail has been stayed. It's that simple.
Ravi Srivastav, here's the thing. Yesterday, like I said at the beginning, at 8 p.m. we sat here and said this is a major win for Arvind Kejriwal because we respect the court. The Rouse Avenue court said bail has been granted. We said great. There is a big relief for this in Arvind Kejriwal. Today, if it has been stayed, we are going to question that as well. But you cannot selectively yesterday say hail democracy and today say fail democracy. This selectivism has to go.
Good evening, Padmaja. First of all, the sadness, the gloom, or celebration are the part of politics. It is nothing is permanent. Things keep on changing. As far as the order is concerned, what I am finding is, okay, India had a right to go, but before the order was uploaded, they rushed the High Court. They could have waited as well to get the order uploaded and then proceeded. But they had a alacrity, they went over. And the order has been now stayed. Point here is, it's the first time one judge has put all the points, most of the points in, she cannot go into the merit of the case. Merit of the case will be dwelt upon when the case comes for trial. It's not a trial. It's only going on a bail application. What she found, she quoted none other than the Honorable Chief Justice of India, who said that don't bring everything on our head. Try to decide at your end. At the lower courts, at the trial court, special court, session court, high court, wherever you can decide it, you place an order at least. And she did it. And she demolished the whole case of the ED.
Respond to Gupta. Chief Justice, no less, has said that bail must be the rule and not the exception.
No. Out of habit, Ravi Srivastav is trying to derail the debate. He is trying to misguide the audience of Times Now. Look, Arvind Kejriwal was the one who approached the Supreme Court. Arvind Kejriwal was the one who's applied for bail in the Supreme Court. So let's not talk about solving the case at the lower court. Also, you're saying that the judge solved the case and it was not about bail or guilt because it was not going for trial. Then what was the judge's observations based on? You are telling us that the lower court judge does not want to go through thousands of pages of evidence that the ED put before her. You are telling us that this was not about bail or conviction. So what were the observations based on that you are claiming is a victory for for the Aam Aadmi Party. And finally, again, point number 38 of the bail order from the lower court. All the opinions expressed, the observations expressed by the judge, they are not an opinion on the merits of the case. So do not claim a victory where there is none.
Ravi Srivastav.
See, I don't know that why I'm not being given the time. It is very clear that what she mentioned in the order is that we have been told to take that decision and we are taking that decision. Now, reading those 1,000 pages are the job when the trial comes in. There is no trial yet. It's only the proceedings for the bail application. And tomorrow also, that the Honorable High Court is going to decide on the stay of the bail application only.
Okay, respond. Sanju Verma. The only reason the judge did not go through all of the voluminous evidence is because that will happen at the stage of trial. It's not expected for a bail application.
Let us be very clear. I was on your channel, with Madhav yesterday. And I don't claim to be a clairvoyant. I'm not into the business of crystal ball gazing. But I had categorically said that the ED is going to put up a tough fight. Because remember what ASG Raju said today. He told Justice Sudhir Jain in the Supreme Court that Section 45 of the PMLA says that the prosecution should be given enough time to present its case. But I was not even given enough time to present my case. Advocate Vikram Chaudhary was given enough time and then the verdict came out and the case was closed. So point number one, yahan yadi kisi ko victim card khelna hi hai, it should be ASG Raju, who was not even heard properly by Justice Bindu yesterday. But forget all this. All the lawyers, I've been in a couple of debates, they've been saying that a bail under PMLA, Section 45 of the PMLA, if a regular bail is given, then there is cause for celebration because it is akin to an acquittal. If on the one hand you're saying that a regular bail in a PMLA case basically is akin to an acquittal, then all the more reason that the prosecution should have been heard very minutely. Why was the prosecution not even given a patient hearing? And don't forget, people who say that bail is the norm and jail is the exception, please educate yourselves. I'm not going to be offensive. But Section 24 of the PMLA talks about what is called the reverse burden of proof. And the reverse burden of proof says that in a money laundering case, it is the accused who has to prove that he or she is innocent and not guilty. It is not the business of the probe agencies to do so. So the ball is in the accused's court, and Kejriwal has not been able to prove beyond reasonable doubt that he is indeed innocent and not guilty. That has been the basic premise of ASG Raju in the various hearings pertaining to the liquor scam, be it Manish Sisodia or be it Kejriwal for that matter. My last point is this. Yes, the BJP does not believe in undermining any particular judge, not even Judge Bindu. But I want to ask people on this panel, when in October 2023, Justice Sanjeev Khanna said that a money trail of rupees 338 crore has been established tentatively in the Delhi liquor scam, Justice Sanjeev Khanna was trolled by just about everybody and everybody's uncle belonging to the Aam Aadmi Party. He was being trolled for 48 hours on Twitter. Justice B.V. Nagaratna, Justice Sanjeev Mehta, Justice S.V.N. Bhatti, Justice M.K. Nagpal of the Special CBI Court. All these people ruled in the ED's favor and the Aam Aadmi Party said, Samvidhan khatre mein hai, Lokantantra khatre mein hai, Ganatantra khatre mein hai. कल आप खुशी मना रहे थे, पटाखे फोड़ रहे थे, आज आप शोक मना रहे हो. अरे वापस संविधान खतरे में है, कल तक संविधान अच्छा था.
Okay, I must bring in Varun Purohit. Only 30 seconds you have, Tushar Gupta. I must bring in Varun Purohit. Yes.
Padmaja, one has to understand that Arvind Kejriwal has been granted exceptions and exemptions by none other than the Supreme Court of this country when he was giving 21 days to campaign for the Lok Sabha. Yes, the ED did not contest that. The BJP did not contest that.
Sanjay Singh has been given bail.
Sanjay Singh has been given bail, and somehow Manish Sisodia has not been given bail. So the merits of the case can be sort of deducted from that. However, one cannot say that the ED has no right to challenge the order that was given by the lower court only because of the scathing observations made by the honorable judge. I think the ED was well within its right. So if the Aam Aadmi Party was celebrating yesterday that the judiciary has been proven right, they should celebrate today as well.
Here's the thing, I don't understand what is this repeated mention of the order wasn't uploaded but they went to challenge it. This is something that the ASG himself, Varun Purohit, has said very clearly that I am moving for an urgent stay. The order was pronounced yesterday, but it has not been uploaded. We were not given a clear opportunity to oppose bail. I was told to finish off the argument quickly. My arguments were curtailed. So he has given the grounds. He is himself saying, yes, the order is not uploaded, but I need an urgent stay. So I am going to move for an urgent stay. What is this entire narrative being built? Today, Atishi is sitting on fast. सुनीता केजरीवाल is standing there and saying कि मेरे पति को एकदम डिक्टेटरशिप ने जो है एकदम उसको टेररिस्ट की तरह ट्रीट कर दिया है. If you are going to trust a lower court, Varun Purohit, then you should trust the Delhi High Court also. आतंकवादी कौन उनको ट्रीट कर रहा है?
पद्मजा जी, एक सेट प्रिंसिपल होता है जुडिशरी में, अपॉर्चुनिटी टू हियर, वेदर इंडिविजुअल है या कोई संस्था है, तो ईडी जा सकती है हायर कोर्ट में अपील करने, उसको अपॉर्चुनिटी टू हियर नहीं मिला है. सेकेंडली एग्जामिन करती है कोर्ट, ऑब्जर्वेशन भी करती है, एग्जामिन भी करती है, उसके बाद जजमेंट देती है. तो बेल जो ऑर्डर दिया है अगर लोअर कोर्ट ने, तो उस पर भी मैटर इज सब जुडिस, आप अपनी टिप्पणी कोई नहीं कर सकता. एक बात अभी और कही गई, फ्लोर ऑफ द हाउस, कोर्ट इज नॉट द फ्लोर ऑफ द हाउस. कोर्ट और बेल और कन्विक्शन में डिफरेंस होता है. तो बेल दी जा सकती है, किसी भी स्टेज पे बेल दी जा सकती है, अपनी जुडिशियल इंटेलिजेंस से कोर्ट डिसाइड करता है इस बात को. इसलिए अब आप कह रहे हो आतिशी धरने पे बैठी हैं या अनशन कर रही हैं, सुनीता जी कुछ कह रही हैं, तब उनके बारे में तो मैं कह नहीं सकता, सबका अपना अपना राइट है, फंडामेंटल राइट है, कुछ कर सकते हैं. लेकिन कोर्ट के ऊपर टिप्पणी करना गलत है. अगर कोर्ट स्ट्रांग कोर्ट हो तो इसको कंटेम्प्ट ऑफ कोर्ट में भी ले सकती है. आप लोअर कोर्ट पे कुछ भी टिप्पणी कर रहे हो, जस्टिस बिंदु का नाम ले रहे हो, आप नाम नहीं ले सकते हो जज का, लेकिन कर रहे हैं. लेकिन जो जुडिशरी है इंडिया की, वो बड़ी स्ट्रांग है और बिल्कुल सबके लिए इक्वल है, उसमें कोई दिक्कत नहीं. अब ये केजरीवाल को बेल मिलती है कि नहीं मिलती है, हाईकोर्ट देखेगा. और ये भी गलत है, ईडी क्यों गई कोर्ट में, तो ईडी तो जा सकती है, उसका राइट है अपील करने का. अपॉर्चुनिटी टू हियर, मैंने कहा सबको, मर्डर करे हुए आदमी को भी अपॉर्चुनिटी टू हियर है, उसको सुनना जरूरी है कोर्ट को, उसके बाद ऑर्डर पास
करते. कांग्रेस एंड कांग्रेस सपोर्टर्स, कल कांग्रेस वाले भी तबला बजा रहे थे, ढोलक बजा रहे थे जब अरविंद केजरीवाल को बेल मिली. आज चरणजीत सिंह चन्नी कह रहे हैं देखो इनकी बेल कैंसिल हो गई, बड़े मजे आ गए. कल भी सेलिब्रेट कर रहे थे, आज भी सेलिब्रेट कर रहे हैं. दैट इज द ब्यूटी ऑफ बीइंग कांग्रेस विज़-विज़ द आम आदमी पार्टी.
दिल्ली की कांग्रेस सेलिब्रेट करती है, पंजाब की कांग्रेस अटैक करती है.
नहीं, पंजाब की कांग्रेस सेलिब्रेट करती है जब बेल कैंसिल हो जाती है. दिल्ली की कांग्रेस सेलिब्रेट करती है एमसी अब्बास व्हेन अरविंद केजरीवाल गेट्स बेल. Punjab Congress celebrates when the bail is cancelled. So that in itself is a huge thing of what the merits of the case are. Because Congress, depending on the state, sees different merit in the case.
The merits of the case are as following, Padmaja ji. The fact of the matter, Sanju Verma ji mentions ASG Raju, who's actually the lawyer of ED, like he's some high court judge. He is there to protect ED. His words cannot be taken as judgment or verdict. And very selectively, ma'am, you speak of your counsel. You don't speak of Abhishek Manu Singhvi's points. Anyway, coming to the next point. The fact of the matter, we also need to understand Arvind Kejriwal was not named under the CBI case. He was also not mentioned in the ECIR FIR. But ED has no answers. Raju ji ke paas jawab hi nahi hai. Also, Padmaja, let me tell you, जो Magunta Reddy का नाम आया है इस डिबेट में, Raghav Magunta Reddy, who was a co-accused based on his subsequent statements, was then Arvind Kejriwal brought to the case. The fact there is vendetta. ED equals vendetta, vendetta equals ED, and ED is nothing but become a dirty tricks department of the BJP. And there we have a spokesperson who's there to defend ED time and again. I think it's high time that we understand that there is a nexus, there is a wrongdoing against Arvind Kejriwal. And I mind you, Delhi High Court in the next 2 to 3 days will give the verdict. He will be out on bail.
Okay, very quickly I want to play out what Charanjit Singh Channi said just for the benefit of our viewers and Varun Purohit, and then Sanju Verma will respond to you. Yes.
ਮੈਨੂੰ ਪਤਾ ਲੱਗਿਆ ਕਿ ਬਾਰਡਰ ਤੇ ਲੜਾਈ ਲੜਨ ਵਾਸਤੇ ਗਏ ਹੋਏ ਸੀ ਕੇਜਰੀਵਾਲ ਜੀ, ਉੱਥੇ ਜਿੱਤ ਹੋ ਗਈ ਹੈ ਤੇ ਵਾਪਸ ਆ ਰਹੇ ਸੀ, ਪਟਾਕੇ ਚੱਲਣ ਲੱਗ ਗਏ, ਲੇਕਿਨ ਰਸਤੇ 'ਚ ਪਤਾ ਲੱਗਿਆ ਕਿ ਅਜੇ ਲੜਾਈ ਹੋਰ ਬਾਕੀ ਹੈ, ਉਹਨਾਂ ਨੂੰ ਵਾਪਸ ਬੁਲਾ ਲਿਆ ਗਿਆ. ਸੋ ਮੈਨੂੰ ਐ ਦੱਸੋ ਕਿ 100 ਚੂਹੇ ਖਾ ਕੇ ਬਿੱਲੀ ਹੱਜ ਨੂੰ ਚੱਲੀ ਹੈ, ਇਹ ਕਿਹੜਾ ਉਹ ਜੰਗ ਜਿੱਤ ਕੇ ਆ ਰਹੇ ਸੀ ਜਿਹੜੇ ਇੰਨੇ ਪਟਾਕੇ ਚਲਾਉਣ ਲੱਗੇ ਰਾਤੋਂ ਰਾਤ.
चलो, चरणजीत सिंह चन्नी कह रहे हैं कि 100 चूहे खाकर बिल्ली हज को चली, इन द केस ऑफ अरविंद केजरीवाल तिहाड़ को चली। संजू वर्मा।
तो चरणजीत सिंह चन्नी की ही पंजाबी भाषा में कहूंगी, चरणजीत सिंह चन्नी ने तो केजरीवाल दी धज्जियां उड़ा दित्तियां। एक है कि 100 चूहे खा के बिल्ली हज ते चली, और हुण भी कांग्रेस वाले इत्थे बैठ के कहते हैं कि आम आदमी पार्टी साडे हितैषी ने। ओके, नाउ लेट मी स्पीक on the mood point.
I had no idea you were so fluent in Punjabi. Kudos for that, Sanju Verma. Go on.
I speak many languages anyway, because I love learning new languages. But I have to say this, Abbas has been trying to provoke me since the start of the debate. Sanju Verma ji ED ki spokesperson hai, Sanju Verma ji ED ki spokesperson hai. But today I will not be provoked. Padmaja ji ke debates par main kai baar आसानी से provoke हो जाती हूँ. Today I have decided आज ये नहीं होगा. ठीक है? Now let me say something to you. When you sit here and say that we should not undermine Judge Bindu, I ask you, how can you be such a big दोगलेबाज और hypocrite? Because 1964 तक तो enforcement directorate एक advisory body थी. Since 2003, the enforcement directorate, while the powers granted to the Central Vigilance Commission, has actually now got the powers akin to a civil court. ED has the powers akin to a civil court. And forget about the enforcement directorate.
Okay.
The CAG, which is a statutory constitutional autonomous body, while Article 147, 148 and 149 of the Constitution has clearly said that there's a 2,500 crore scam, which was perpetrated by the Kejriwal dispensation at the expense of the Delhi taxpayer. तो पहली बात तो ये एनफोर्समेंट डायरेक्टरेट और सीबीआई को भूल जाइए. सीएजी एक संवैधानिक बॉडी ने भी केजरीवाल की धज्जियां उड़ाई हैं और कहा है कि लिकर स्कैम हैज हैपेंड. माय लिमिटेड पॉइंट इज दिस. आई विल एंड बाय जस्ट सेइंग दिस. Repeatedly today it was discussed whether a bail should be given or not, and whether a stay should have indeed been put on what Judge Bindu did by way of giving a bail yesterday. The final argument of ASG Raju was this: according to section 45 of the PMLA, bail can be granted to an accused in a money laundering case only if two conditions are satisfied. There should be prima facie satisfaction that the accused has not committed the offence.
Okay.
And additionally, he is not likely to commit any offence while being on bail. So whether he has committed an offence or not, that is still up for debate. But the fact that he is likely to commit an offence when he is going to be given a bail, there is no doubt about that. But because even when he was an interim bail, he was not supposed to discuss the merits of the case.
Okay.
He said, Delhi walo, mujhe chunav jita do.
Ravi Srivastava wants to respond.
Recorded in the judgment.
Mr. Srivastava, yes, go on.
This is what ED does. They have said it that investigation is an art. And by artistry, they can give a lollipop to anybody and extract any statement. And they can put any innocent person in the jail. This is what Justice Nyaya Bindu has recorded in the judgment. Have you read it?
Okay. By the way, as far as these witnesses are concerned, let me actually set the record straight on 2 to 3 things. Then Tushar Gupta, I will bring you in. By the way, that ED has said very clearly in the Delhi High Court that this entire assertion of Arvind Kejriwal that none of the approvers have taken my name is false. What have they said? That neither Raghav Magunta nor Sharath Reddy have ever been put any question regarding the role of Arvind Kejriwal, which is why just to say that a person has not taken the name of Arvind Kejriwal does not prove anything. Point number 1. Point number 2, for everyone who says that Mr. Reddy is being, given a long rope by the ED simply because he's turned approver. Despite turning approver, ED has attached Sharath Reddy and Raghav Magunta's properties to the tune of 115 crore rupees. And this has been mentioned in the charge sheet against K. Kavita. So that's as far as the, Magunta Reddy is an instrument and he's been given a long rope by the ED is concerned. They have been acted against. Tushar Gupta, your point.
The judiciary will take a call, whatever it has to take, be the lower courts or the apex court, and I think no one will want to contest that. But I want to question the hypocrisy of people like Ravi Srivastava. Yesterday on a debate on Times Now, we were sharing a panel and he said it's the win of democracy. One should hail the judiciary because it's been fair and square when it comes to Arvind Kejriwal.
And we did.
What has happened today? What has happened today? That the agency is extracting statements out of people, that the case is compromised, that this is art and whatnot. Look, the Aam Aadmi Party and their coterie of supporters need to understand that the health of Indian democracy doesn't depend on your mood swings. आज बेल नहीं मिली तो डेमोक्रेसी खतरे में है, आज बेल मिल गई तो डेमोक्रेसी, लॉन्ग लिव डेमोक्रेसी, आज बेल नहीं मिली तो धरने पे बैठेंगे, आज बेल मिल गई तो पटाखे फोड़ेंगे. पूरे दिल्ली पर ये बैन लगाते पटाखे फोड़ने पर, और बेल का एक ऑर्डर के आ जाए इनके घर के बाहर ढोल नगाड़े भी बजेंगे, पटाखे भी फूटेंगे. The hypocrisy here is astounding. You have to respect the judiciary. If you have a case that you feel can be defended in the court, go defend it in the court.
And just to mention that if the Delhi High Court eventually in 2 to 3 days from now does go ahead and give bail to Arvind Kejriwal, it will still be hailed as a major win for the Aam Aadmi Party if it happens. But for that, all evidence must be considered, and to ask questions about why it was not done still remains perfectly legitimate, because remember, we are a democracy even if some people tell you otherwise. Thanks, gentlemen. Sanju Verma for joining me on Debate.